So, good afternoon. My name is Gary Darnielle, and I'm a Springfield hearings official. For the record, it's about 1:41 on March 5th, 2024. This is a time for a public hearing on an application to amend the Springfield zoning map to rezone tax lot 2320, assessors map 17032443 from neighborhood commercial to residential R1. This is planning file 811-23-000-282, type 3. Jim McLaughlin is the applicant in this matter, representing the property owner, Amy McKay Romero of McKay Commercial Properties in this matter. Before we begin the public testimony portion of the hearing, I'd like to explain some of the procedures that we follow and some of the legalities that attach to the hearing. It shouldn't take too long. I'll bang my gavel when I'm finished to wake you up, and then we can begin with the public testimony. The approval criteria in a zone change can be found in Springfield Development Code, section 5.22.115. In summary, they are: 1, consistency with the Metro Plan policies and diagram; 2, consistency with applicable refinement plans, plan district maps, conceptual development plans, and functional plans; and finally, 3, whether the property is presently provided with adequate public facilities, services, and transportation networks to support the use, or these facilities are planned to be provided concurrently with development of the property. Testimony, argument, and evidence offered this afternoon should be directed towards these approval criteria or to other criteria that you believe may be applicable to the decision. A failure to raise an issue accompanied by statements or evidence sufficient to afford the decision maker and other parties of an opportunity to respond to the issue will preclude your ability to appeal my decision to the Oregon Land Use Board of Appeals. And I'll talk a little bit about the appeal process in just a moment. By statute, you have the right to request that the record be open an additional 7 days. You also have the right to request a continuance of the hearing. However, that a continuance is discretionary with the hearings official. You have to demonstrate why merely holding the record open for a period of time isn't sufficient to address any concerns that you have. At this time, I wish to declare that I've had no conflicts of interest or any ex parte contacts in regard to this zone change. A conflict of an interest is a situation where the decision maker, his or her family or business would financially benefit or suffer by the decision. An ex parte contact is a communication to the decision maker that includes substantive issues and that occur outside this public venue. At this time, members of the audience may challenge my impartiality, and you reserve the right to make those challenges at any time during the hearing. Hearing no challenges, we'll go a little further. Regarding testimony, this hearing is electronically recorded, so please use the microphone at the podium if you're testifying live, and I would appreciate it if you introduce yourself prior to offering your testimony, so that if a transcript is made of the hearing, we can accurately put your name to the testimony that you've offered. We begin the presentation of the hearing with a staff report. This morning we have Mr. Thomas Sievers, a senior planner with the Springfield Planning Department, and he is joined online, I believe, by Ms. Christina Kratz, the Assistant City Attorney. Following the presentation of the staff report, I will hear testimony from the applicant. Following that testimony, I'll hear testimony from those in the audience or online who wish to testify in support of the zone change. Following all that testimony, I'd like to hear testimony from those that would not like to be identified as being either pro or con to the zone change, might have questions or comments to be made. Finally, I'd like to accept testimony from those who wish to testify in opposition to the zone change. And I have one sign-up card for that purpose. At the conclusion of the testimony from the public, I'll turn to staff and see if staff wishes to address any of the testimony that was raised. And then finally, there'll be an opportunity for the applicant to summarize their comments and possibly address any comments that were made during the public testimony. Once the record closes, I will begin my deliberations and ultimately issue a written report, a decision. The decision will address evidence presented, provide findings of facts and conclusions of law. And I'll try to issue that decision within 10 days of when the record closes. If you're a party, such as you've signed a sign-up sheet or the applicant or the property owner, you'll automatically receive a copy of my decision. My decisions can be appealed to the Oregon Land Use Board of Appeals, and you have 21 days of when my decision is final to perfect your appeal. And that means getting your filing before the board. Are there any questions regarding our procedures that we follow? We try to be fairly informal, so don't be afraid. Okay, then I would like to hear from the applicant. Oh, I'm sorry, the staff. Mr. Sievers?
Sir. Good afternoon. I am Tom Sievers, Senior Planner with the Current Planning Section. Today, the hearings officer is requested to consider a zoning map amendment for an approximately 0.88 acre property addressed as 2125 Yolanda Avenue in North Springfield. Next slide, please. The area proposed for a zoning map amendment is outlined in red. Once we can get the dialog box out of the way. Okay. It's outlined in red with frontage on Yolanda Avenue. The zoning map amendment was requested to facilitate a change of use from commercial to residential to build a single unit residence. The property remains unannexed and the applicant will demolish the commercial structure to facilitate construction of the dwelling, pending approval by the Lane County Sanitarian. Next slide, please. The site is currently zoned neighborhood commercial with the urbanizable fringe overlay. There is a small commercial structure on the site now, which will be demolished to build a single unit residence. Next slide, please. The applicant has proposed a zone change from neighborhood commercial to R1 low density residential while retaining the UF10 overlay. In staff review, it was determined that the property was outside of the distance to sanitary sewer to require annexation. As such, the applicant has not proposed annexation and will seek Lane County Sanitarian approval to allow a new single unit residence and septic system on the site. Next slide, please. There are 3 approval criteria for zoning map amendments in the Springfield Development Code, which were addressed in full in the staff report and summarized as follows. 1, consistency with the applicable Metro Plan policies and the Metro Plan diagram. The requested zone change from neighborhood commercial to R1 residential will be consistent with the Metro Plan as the underlying designation is for low density residential. Rezoning the subject property from neighborhood commercial to R1 residential is consistent with provisions of the adopted Metro Plan and the Springfield 2030 Comprehensive Plan, residential land use and housing element, and the urbanization element as in effect on the date of submittal. The second criteria, consistency with applicable refinement plans, plan district maps, conceptual development plans, and functional plans. The property is not within an adopted neighborhood refinement plan or plan district, but is within the functional plans of the Transportation System Plan and the Public Facilities and Services Plan. These plans are based on plan designation, not zoning, so no changes are needed to the functional plans. Rezoning the subject property from neighborhood commercial to R1 residential is consistent with the provisions of the city's adopted functional plans. And lastly, the third criteria, the property is presently provided with adequate public facilities, services, and transportation networks to support the use, or these facility services and transportation networks are planned to be provided concurrently with the development of the property. As detailed in the staff report, a full suite of public utilities and services with sufficient capacity to support the requested rezoning from neighborhood commercial to R1 residential are available within or on the perimeter of the subject property, and also pending Lane County sanitary approval. Because all applicable zoning map amendment criteria have been met, city staff recommend that this application be considered for approval. Thank you for your time, and I'm here for any questions.
So the property currently has a functioning septic tank system?
That's correct.
That's the only question I have. Thank you. So at this time, Mr. McLaughlin?
Good afternoon, Mr. Darnell. My name is Jim McLaughlin. My mailing address is 2600 19th Street in Springfield, Oregon, 97477. The subject property involved in this request is located at 2125 Yolanda Avenue, map number 1703-2443, tax lot 2300. It is parcel 2 of a partition that was approved in 1992, City Journal number 91-07103. Its use as a small, it is in use as a small convenience store and beauty shop. Actually, there is no convenience store any longer. The subject property is located outside the city limits, but inside the UGB. The zoning designation for the subject property is neighborhood commercial, and the subject property is designated low-density residential in the Metro Plan. The Metro Plan does not have a specific designation for the neighborhood commercial uses in residential. The subject property is not any part of the refinement plan. On the east, south, and north of the subject property, the properties are designated low-density residential, and the property was also designated neighborhood commercial in a previous zone change that was approved by the city, and I need to find the date. I don't have it right off the top of my head. When it comes to the issue of wastewater, I already have the Lane County City referral form signed and approved by the city of Springfield, ready to go in. I'm not going to turn it into the county sanitation office until we get through this approval process.
Do you want that document in the record?
I do.
Hand it to staff, please. Have it marked accordingly. I don't know how you've recorded the exhibits to date, so. Okay,
That's the end of my presentation at this point, unless you have any questions.
what was the tax lot number again?
2320, I might have missed, it's 2320.
Okay.
Yeah, my narrative was wrong.
It was. You deducted 5 points.
Thank you.
Are there others in the audience that represent the applicant?
No, I'm the only one here.
Okay.
Thank you.
Thank you.
Just for the record, we'll stamp this exhibit A for the
Okay.
record.
Okay. Thank you. Are there others in the audience or online who wish to testify in support of the application? Hearing none, are there those in the audience or online who wish to be neutral but ask a question or make a comment? I have you against. It doesn't. Does it matter?
If
If you'd
what?
like to, excuse me.
I would like to speak, but I couldn't hear what you just said. Sorry.
Will you be speaking in opposition?
Well, I could be neutral. I just would like to find out some more information.
Okay, could we have your name, please?
My name is Linda Wilkins. I live directly behind, or I own the property directly behind the site
Okay,
that they're speaking about, and it was my intention to move in there here in the very near future. And my big concern is that that possibly can I be assured that just this single family residence will be put on here and they won't hold on to it for another year or something, then change their mind and come back and want multifamily?
well, I can't answer that. The zoning district allows a number of uses. The applicants can address that question if he chooses to, right now. It's a pretty informal hearing.
Ms. Wilkins, I can tell you that through this process, there was at one point a consideration to create 3 parcels on that lot because it is about 38,000 and the owner decided against and they only wanted to make 1. This would be the time to do it. If not, we'd have to go back through this process and at least create a partition or do other things. So it's my understanding the approval of this land use action will only allow 1 single family dwelling, and that's what the current owner has specifically requested.
Thank you. Is it going to be, could you tell me if it's going to be 1 or 2 stories?
I can't answer that. I haven't seen any design.
Okay, well, I just want to go on record saying that I was in the real estate field for quite a few years, and I recognize the name as a very big developer in our area if they're related to the same family. I'm kind of assuming that. I'm just, I'm not sure if I should do that, but I get very concerned about when I hear names that I know that have done big projects in the past. They can turn around and, wait a year and then come back in and say, oh, we decided not to do that. We're going to try some other way and make apartments or townhomes or whatever. And that would really make my property values go down. And, I worked all my life to get some of these properties that I could retire from. So I really don't want that to happen. I guess that's my biggest concern.
Okay,
Would they
thank
be
you.
submitting house plans too in the near future?
Not to the hearings official.
Sorry.
Right now, there won't be any house plans or anything else required in this land use action. There will be house plans at some point for a building permit, but no, there won't be anything else than what you see. And I really can't speak factually on what I think the future for this is, but I can tell you that discussions were made and this was the final decision to go down to only 1 residence. So where that leads, I have no ability to let you know one way or the other.
Well, like I said, I'm ex-realtor and I know this family. So can I ask you, and you don't have to answer this, but how are you in relationship to the property owner? Are you a developer for her or just?
I'm just a consultant and I've done other work for him in the
Okay.
past.
Okay. Can I ask you, is the same McVeigh, the same ones that have the Oakway Mall? And
I think it's a relative. I don't think it's the direct same.
well, I didn't expect they're older people, but I just wondered if they are in the same family. That's all. Thank you.
Thank you. I have a request to speak from Ms. Rebecca Weed.
I'm new to this whole process. I've only been a homeowner for a few years. So my concerns were a lot of what Linda said, that just concerned for how it impacts our neighborhood. We really loved our neighborhood being a single, like, a smaller neighborhood, a more residential neighborhood. And so trying to keep that feel still in our neighborhood. I was glad to hear that it was a single family unit. I'm hoping that doesn't change in the future, but I'm understanding correctly, that would have to go through a whole nother process for it to be switched to something like apartments. Or, so even though the zoning R1 covers that it could be up to 10 filling units, it would still have to go through the process again to build a different structure. Is that correct?
Yes.
Yes, okay. I think my only other concern would just be how it impacts the neighborhood in terms of the fact that this is kind of a spot for the schools a little bit. The middle school parents will often park in that parking lot and the kids will walk down. Or like sometimes we've had, and I'm sure it's been done with permission, but like it's just kind of become a little spot on the neighborhood. Like we have this artwork that the city's done there. And it just kind of makes me sad to think some of that is potentially going away to someone's house. I hope that they are a good resident, that they are kind. But that's not something that pertains to the hearing, I guess. So I guess we'll just have to see.
Ms. Weed, how close do you live to the property?
I live on Ranch Drive, so behind the property, kind of, it's a catty corner. I can see it from my backyard, but it's not directly from my house.
Okay.
So
Are there others online or in person who wish to testify in this matter? Does staff have any final comments?
Yes, I did just want to point out that any further intensification of this lot would require annexation and not having the ability to be on a septic system. So having more than just a single unit residence would require further land use approvals in the form of annexation, which is a lengthy process that would draw things out. But as it sounds from the applicant's representatives, that they are only planning at this time the single unit so that it can be on the septic system approved by the sanitarian. Further land use actions that could take place through the middle housing rules could see an intensification on this lot in the future, which would be in line with the R1 zoning up to a certain density with certain housing types. But other than going through annexation at this point, that's kind of a far reach.
Okay.
Just want to jump in real quick. Christina Kraz for the city. Just to clarify, under Oregon state law, duplexes are allowed on every lot that a single unit dwelling is allowed. So if the septic system were adequate, the property owner could also develop a duplex via a building permit process, which is something that is allowed in our code per requirements of state law.
Yep.
And that would be without annexation as long as the county determines the septic is adequate.
Okay. Thank you. Does the applicant have any wish to summarize their statement, closing argument?
No, I think I have, my statement stands on what I can say factually. And I appreciate the concern. I actually used to live on Ranch Drive, so I understand that, but I don't, well, I can't tell you what I feel. I can only tell you what I know, and I don't expect anything to change beyond the single family dwelling.
Okay, thank you. If there's no further testimony before the hearing is official, we will close the public hearing and I will begin my deliberations.
Yes, anymore.